The appeal filed by the Karnataka Power Transmission Corporation Limited is partly allowed, and the review and judgment shall stand set aside. We find that there was no contract concluded within the meaning of Section 27(2) of the Act. The matter came back to the High Court for reconsidering points 3 and 4 accommodated by the High Court. The first respondent shall pay to the appellant a sum of rupees 50 crores within 8 weeks. As regards further liability to pay, it will levy and depend upon the decision of the High Court. So also the payment of rupees 50 crores by the first respondent under this judgment will be subject to the determination to be made by the High Court. The appeal filed by the Karnataka Electricity Regulatory Commission will stand allowed to the extent that the remarks made against it in the interim judgment shall stand set aside as indicated herein before. Parties will bear their respective costs.
Deeply grateful, my lords.
I seek the indulgence.
Yes.
I seek the indulgence of this court to allow me to mention a matter. I am coming on behalf of Animal Welfare Board of India to get permission to file written submission for the matter listed before the Constitution Bench tomorrow. I may please be granted permission for the same.
How many pages is it?
It's 41 pages, 5 pages of submissions and annexures.
It is allowed. Yes.
Please,
Yeah.
and matters of this moment calls for deep application of mind, considerations, and the soul of thoughts which will fit with the level of debates. So I try to visit and revisit again and again, so that as far as assistance to the court is concerned, there's nothing is wanting. But few broad thoughts I thought I'll share with the Lordship before we get into the nitty-gritties of what
Tell us one thing only.
Your Lordship, please.
If we'll see 324(2), it says subject to the provisions of any law made by the Parliament. Subject to the provisions of any law made by the Parliament.
Your Lordship, please.
Our request is please take instructions and inform. Either there was no necessity to frame any law on the subject, or it was never brought to notice that some law is required for the purpose of implementing clause 2,
Your Lordship, please.
which calls upon the authorities to make an appointment to the Chief Election Commission.
Right.
Because we are now 76 years down the line.
Your Lordship's right.
And merely because somebody knocks the doors of this court and call upon to examine the issue, then only you come out and say that we'll examine as to what is to be done on our part. And why your obligation cast by the constitution makers has not been so far acted upon.
I will try to address that question. And
because the judgment which you are citing, Vineet Narayan and all, there was no legislation, and this court thought some legislation is required on the subject, for which the Parliament in the ordinary course of business has to take a call. Anyhow, as per the social structure changes, law also required to be.
Absolutely, no doubt about it.
But in this peculiar matter, there was already an obligation by the constitution makers put on that please make the law on the subject for proper implementation and if giving effect to 324(2) by making an appointment.
That's one way of looking at whether the Constitution itself casts an obligation. And the question arises at what point of time?
What is your stand?
What will
You
be
say you are not required?
No, I'll address that question. I first
No, straight away.
lay down.
According to you, is not required, or if the court will call upon you, will go ahead.
No, either way, I don't think this question, with great respect, can be answered either or way. So let me try to explain why I take that stand, and then presently probably depending upon the discussions we have in this matter, I may try to proceed further.
All right.
Now let me try to, because this issue, like in several other earlier situations cited before the court, are broadly built on principles of a vacuum or a silence or a gap. Way back in 1948, Michael Foley's book on the silence of constitutions has been the subject of some discussion at some point of time. Before I take your lordship into that, I just want to reflect on how one may look at that. Under that very inviting literature by Professor Lawrence Tribe on the invisible constitution again, has also triggered a lot of debates both in US and outside. So today, we are certainly, while talking about and expounding the Constitution, ever since you Justice Marshall talked about it. One important thing which comes to your mind while screening the whole developments taking place in the past 2-3 decades across the globe in different constitutional courts, post-World War, importance of human rights, and ensuring that fundamental rights get their best possible comprehension and understanding, protection, promotion, etc. So almost across courts in Asia, courts in Europe, there is some movement towards ensuring that the courts play an important role. So therefore, today we have a lot of literature which say constitutional courts as mediators, constitutional court as positive lawmakers. So we have all those interesting literature which scans the role played by the constitutional courts across the world. But besides all that, while all that is very important, because if the courts do not play a role, then perhaps if the salt lose salt, who else will do it? That's how it is. But while it is said so, some fundamental principles will also be always kept in mind. I mean, I am not going back to a doctrinaire Montesquieuian theory of separation of powers. I think that is a line. That's a line which the court will move very wisely from time to time. Where it is needed, well, move it wisely. Where it is not needed, the deference principle will certainly apply. And when I say that, I don't say the deference principle will be mechanically applied with a closed mind merely because the state calls for a deference. Just as you said, we are expounding the Constitution at a given point of time. Very simple example in any book on interpretations I choose, the word telegram. So it did not contemplate telephone. So you said telephone would be included in telegram. Many pedestrian examples. So when you come to a constitutional meaning, of course, they stand at a very higher level. Some commentators say the constitutional courts are not merely adjudicating. Adjudication relates to pleadings, proof, evidence, evaluation of evidence, etc. We slightly stand on a different level. That's why some people prefer to use deliberation. Again, after the Canadian Charter, people began to write on the deliberations as the interplay between the court and the state. So these are all theories which have now grown around the role of the constitutional courts. But what would probably come to the court's mind at any given instance is, how do we really merge them all together and have a manageable standard which the court will be able to deal with. And then either demand from the state that you have an obligation which is clearly visible either from the plain reading of a statute or a constitutional provision. And I don't find any explanation why the obligation has not been discharged. And therefore, we call an explanation from you and find out how it can be taken further. Or where that obligation is not cast in so many, plain words. Sometimes the court may not try to read an obligation into it, except, for instance, like the Julius versus Bishop of Oxford, power coupled with duty. So in all those circumstances, the court will say, is there really an obligation? And if there's an obligation, which Constitution contemplates, what kind of an obligation it is, when will it be triggered, at the trigger point being reached, or if it has not been reached, then how will the court look at it? I thought I'll just flag all these broad statements and propositions before I come to 324. So let me just quickly take your lordships through this. And before that, I was...
Mr. Attorney, you accept that court has a role to play in cases where there are, okay, I wouldn't call it, we would call it gaps. There are scope of interpretation of constitutional provisions as regards obligation of the state.
Yes, let me only...
So jurisdiction of the court you are accepting.
Correct. Let me only...
Now we are discussing only the contours or the outer limit of that jurisdiction in the facts of the given case.
Right. I just want to qualify this gaps and silences theory. I'll come to it a little later. I'm going to expound on that.
One more thing.
Your Lordship.
You must have realized the obligation. But for that, now where is the question of constituting a committee, that is Goswami committee? So having constituted it based on a meeting which was held on 9/1/19.
No.
That was constituted for this purpose, to study. So you know that an obligation is there. Committee was constituted.
I'll try to respond to this question.
Have a study on it.
I'll try to respond to this question. Let me go in some, I'll make a note of each one of the questions and come in a seriatim.
Yes.
Attorney General, I just wanted to
Your Lordship.
bring two aspects.
Your Lordship.
Thanks to Wikipedia over the weekend, we just keep this in. Just a phenomenon which I wanted to elicit your, you'll give a copy to, one copy to this. If just keep, that's for all of you together. It's just what we just sort of found out a little bit of sort of statistics. Now, the first, the Chief Election Commissioner was Sukumar Singh.
Yes, sir.
Now, he was, of course, a civil servant. Now, the total period, Ashok Sen, in fact, brother of Ashok Sen, the distinguished lawyer. Now, the total period that he had was 8 years and 273 days. And the next one was, incidentally, the first law secretary, KVK Sundaram. He had 8 years and 284 days. Now, he was a very distinguished man, principal author of the white paper, which was used to guide India into states. Then came SP Sen Sir Verma. We don't have information, but he had nearly 4 years. I think it's about 4 years. Then came Dr. Nagendra Singh, I mean, all known to us, who became
ICJ
president.
ICJ.
And he had, of course, 128 days, but that is the shortest you will find in the 50s and 60s. Then you had T. Swaminathan. Again, he had 4 years and 10 days. He was a member of the civil service, cabinet secretary. Then you had Shakta. He was Secretary General of 3rd Lok Sabha. I don't know whether he was a civil servant, but I think he was a very distinguished, because he wrote the book on parliamentary
Sure, yes,
procedures.
yes.
Very distinguished author. And then we had R.K. Trivedi, he was a civil servant, but he also had 3 years. Then we had R.V.S. Peri Shastri.
A very distinguished academician.
Very distinguished academician. We'll come to it as we turn. Now things turn out, He had 4 years and 4 months. Started his career as a teacher, I believe. We don't know whether he was a member of the Law Commission.
He was.
And then we had this temporary blip, if I may call it. We has Ramadevi. She was a politician.
I think she became a governor.
She was a governor,
Governor.
and then she became a
That's
AC member.
That's right.
That tenure was very short-lived. She was 69 days. Then you had, of course, T.N. Session, who took over on the 11th of December, 12th of December 1990, lasted till 11th of December 1996. And we don't have to say about him. I was obviously sort
I
of.
just want to correct your lordships on one small thing. Ms. Ramadevi was law secretary, union law secretary. So I don't
think she was a civil servant.
Well, union law secretary is
For
what
some
the
time.
book co-authored by her says.
Was he a civil servant?
I'm
Just
not
check up.
sure about
Book on election laws.
Yes, book on election.
Just find
Like
out whether she was a
Vendiratha
civil
and-
servant, because Wikipedia can also be.
Yes, yes.
The credit goes to Wikipedia. But we wanted to this for another purpose, and that's going to come.
I mean,
Yes, yes.
And that's going to come now.
please.
M.S. Gill, he had 4 years, and that is 96. Now, please mark from now onwards. That is from 2007 February 2004. Your journey begins when the longest period is hovering around 2 years.
Yes.
You'll see 2 years. Lindo had 2 years. He was a civil servant. P.S. Krishnamurthy, he had 1 year and 69 days. B.B. Tandon had 269 days. N. Gopala Swami, he had.
He was there for quite some time.
He was there
With the
3
Home
years.
Secretary.
He was there for 3 years.
I
He was there for 3 years. Then we had Naveen Chawla. He had 1 year, 89 days. Qureshi, 1 year, and I think 369 days. But 2 years, nearly 2 years, all 2 years. Now, V.S. Sampath again, 2 years. H.S. Brahma, I think it's 92 days. Then over the page, Naseem Zaidi, again 2 years. Anshul Kumar Jyoti, he had 200 days. Om Prakash Rawat had 312 days, less than a year, all less than a year. Sunil Arora had 2 years and 131 days. Sushil Chandra had 1 year and 31 days. Rajiv Kumar had 188 days. That is less than a year.
Yes.
Correct? And of course, we have the latest is Arun
Yes.
Goel, but we don't know about him.
Right.
The question is this.
Yes.
You see, under the 1991 Act, the term
Give the right.
of the Chief Election Commissioner is to be 6 years.
Or 65.
It is hedged in with a limitation following from the proviso, which says, provided, however, if he attains the age of 65 prior to the expiry of 6 years, that his term will come to an end.
Yes.
Correct? Now, what we are trying to point out to you, and we expect an answer from you, because
Yes.
this is a very, very, very disturbing trend,
Yes.
which is this, that after 2004 particularly, the slide has begun in terms of picking up those persons whom, of course, the government knows the date of birth. They know that they will never ever get anywhere near close to 6 years.
Yes.
So the term is a very highly truncated one, known from the very beginning. So in this way, this so-called independence that you sort of pay lip service to, I'm sorry for saying that,
Yes.
is completely destroyed by having this kind of a term. See, for anybody at the helm of affairs of an institution, one of the most important things is the time he gets to, do what he wants to do. So you are actually, all this happens because it is relevant how it is connected.
I see.
The appointment process is how you carry out the appointment process. Then if you have a procedure, because you have, of course, the first proviso, as far as the
Yes.
Chief Election Commissioner is concerned, to Article 324(5), which says that you can't be removed except on impeachment.
That's right.
And secondly, his conditions cannot be varied except,
That's
not disadvantage. It's
That's
a constitutional protection. But this is a protection which you can avail of, provided you have a term. Now, your term is 188 days, your term is 160. I mean, this is a trend from 2004. Be it the UPA government or be it, so I did a little maths there also. And I found that, when it is from 2004 to 2012, we take it, for 6 years, 6 chief election commissioners for a period of 8 years. Now, 6 into 6 will be 36. That is one math. The other math is, for the period after the present government took over, that is 2015 to 2022, for 7 years, you have had 8 chief election commissioners.
Actually, one of the reasons why this is happening is that I'll tell your lordship what is happening.
No, whatever is happening, we are telling you.
Something very relevant.
This
relevant.
is something which we have to factor in when the discussion takes place.
Yes.
I look at the broader.
What they have done, my lord, what they have done after the Thursday hearing.
We know that.
Thursday hearing, I mentioned.
We know that.
They have hurriedly appointed a third election commissioner
seen
between
that.
Thursday and today.
We have seen that.
And-
We are conscious.
No,
And
don't
that-
say hurriedly appointed.
But this is this is statistics which cannot be wished away, which stares at our faces, which we'll have to factor in when we, take a view either way,
I understand that. I am not.
which we are placing right
I,
at
I'm,
the
so,
beginning of your
I'm
answer.
so glad you lordship have put it to me. And
Now, the second aspect is,
yes.
again, we just sort of we'll give you. These are some of the laws, relating to election commission, and we thought that we have to look closer in our neighborhood as well. We are going to England. We thought we should start with Sri Lanka, for example. And so sorry,
No, your lordship,
we have
We-
made a.
Yes.
We just expect that you will give it back to us.
Yeah, we do.
Little
I
nicerly.
had also occasion to look in
The
the
government property, so that we
No.
library. So we got one more actually, we can just. So what we've done is, if you see the first is Sri Lanka,
Other countries. Sri Lanka.
it says, sub-article 3, it's incorporated in the constitution, article 103, sub-article 3. They go as far as, prohibiting, no person shall be appointed as a member of the commission or continue to hold as a member if he is or become a member of the parliament, provincial economy, local authority, or is appointed as a judicial officer or a public officer. Okay, that is one thing. Then you have Nepal. See how far they have gone. They say that at 245(2), the president shall, on the recommendation of the Constitutional Council, appoint the chief election commissioner and the election commission. So they have made that. Now let's go over to Bangladesh. There, of course, it is closely, they have this almost same subject to provision. I think this is modeled on our constitution, and certain restrictions are there. If you can skip it. Now let's move over to Pakistan. You see how they have structured it in terms of the criteria for appointment. No person shall be appointed commissioner unless he has been a judge of the Supreme Court, or has been a senior civil servant, or is a technocrat and is not more than 68 years. Now, they have taken pains to also articulate what is meant by a senior civil servant, a technocrat, etc. And then the Prime Minister shall, in consultation with the leader of the opposition in the National Assembly, forward 3 names for appointment to the commissioner to a parliamentary committee for hearing and confirmation of any one person. And various provisions are there which we sort of commend for your consideration. Now, if you come to the next one, you'll find
UK.
UK. That is another model you'll get there. And if you come to the US, the last one, the Federal Election Commission, so it goes in for the Senate confirmation. And there you see at 3, Arabic 3, members shall be chosen on the basis of their experience, integrity, impartiality, good judgment, and member, etc., etc. And various other restrictions are put. So we just thought that we should place this for your consideration. You want us to remain behind other countries, particularly having regard to the disturbing trend we found. How it has become a license, how they think there are no checks and balances. Nobody can question them because there is no law. There is nothing is like you said, we are talking about the silences of the Constitution.
I see that.
How the silences of the Constitution are being exploited. There is no law. Like you said, there is no law, there is no check. Nothing can be done. Legally, yes, they are right.
I think this first blush, having seen these, every one of these constitutions mentions mandatory using the term of the Chief Election Commissioner and Election Commissioner. It also provides for removal to be on par for both the CEC as well as the Election Commissioner. I just thought, we're very grateful for this level of research done, which we could have done.
Not on the lexical meaning of may or shall. It depends on the context in which it is used, and then how an authority perceives the nature of the duty. Therefore, we did not go on those lines. I've also seen many of these.
You would have seen it.
Many of this
constitution. You wanted to just place it.
And for instance, the Canadian electoral reform.
That's right.
The Constituent Assembly had looked into that. So, at some broad and except this very detailed, I've also
one more last observation so that you can just think of it when you reply. See, in the Constituent Assembly debate, you notice actually the tide was turned by the member from Bombay. What's his name? I forget the name. He would say that the Election Commission is contemplated as an agent, as a part of the government.
Correct.
And what is his name?
I'll just pick it up.
Munshi came. So Professor Munshi remarks. He said, "Let there be a law. Let it be worked out, and it can be a part of the government. It should not be divorced entirely. It can't be given independence because all the resources are being provided by the state." So it is necessarily dependent upon the state.
Yes.
It cannot have an independent role. He goes to even say it cannot become a super government.
Yes.
So those, the point is at the time when the founding fathers, because when you talk about expounding the Constitution, as you know, there are 4 theories.
Right.
Which the US Constitution, the originalist theory, which is what the founding fathers had in their minds at that time. And, future generations are hidebound, they can't go behind it.
Yes.
Whether we should stick to the originalist theory, which is what some judges in the US Supreme Court, advocate, but whether we should do that in conditions peculiar to our country and knowing how things are, power when it is obtained, how it is used.
I know there'll always
2004 to 2020, I've given you statistics.
Yeah, absolutely. There'll always be a perspective from that point of view.
That's right. We have to deal with our conditions.
That's right.
Our men.
That's right. And while we enter into that,
sorry, we have taken.
No, certainly. I'm extremely grateful for inviting me, and I've also done some little exercise, but not fully, as your lordships have done. I called for some information and then looked into it, and one may throw some light on it. After probably I'll get some more instructions on it. How to help
go ahead.
Lordships. But before I broadly looking at pre-1991 and post-1991, can be broadly classified. Why it might have happened like this is too difficult to guess. But then probably one has to dig into the archives, what happened 8 years, long years. But now that the law is there after 1991, how do you go about working under the law 6 years? Whether it is obligatory, can you curtail it? Will you not look into it more closely and say, yes, I am bound by it? All those questions are very important. And certainly one cannot shy away from those questions.
Yeah.
I'll try to, but broadly speaking, when I looked into this, my first question was, what is the position in other countries? So I tried to look into it. If the constitutions in other countries, if the constitutions themselves proceeded on certain lines, then we are talking about a constitutional scheme. So a comparison between two constitutional schemes may or may not be too appropriate, except where distinct constitutional schemes notwithstanding, the working under these constitutional schemes are given some lessons, useful, which can be borrowed. That's how I look at it. But instead of getting into those very narrow dividing lines. But if the Constitution of India says 324B shall be like this, and it also provides a certain understanding that over a period of time, whenever the time may come, Parliament may enact a law to deal with certain matters or subjects under 324B 1, 2, 3, etc. Then the question that may arise for consideration is whether the Parliament has done something under the Constitution is one question. Whether the other parts of 324 1 to be the place of the President, how the President will exercise her or his discretion, pointing, so and so, they are parts of the Constitution. It is one well-settled principle that an original provision of the Constitution cannot be put to challenge. And Violation Prashant Bhushan in his submission says, declare the appointment procedure as unconstitutional. Court will not do that. An amendment to the Constitution because of 368 powers, all those basic structure, of course, that will certainly be a matter for consideration. Therefore, a very important distinction in the original provision of the Constitution, as it stands, the court will not strike it down. But where it becomes necessary, that's why in the context of fundamental rights, well, let me put it like this. We keep saying fundamental rights are an integral part of the Constitution. Part 3 and Part 4 are the two chariots, wheels of the chariot and the constraint, etc. But I suppose if fundamental rights permeate the entire constitutional scheme, let us proceed on that footing, so that we have a very comprehensive view of the Constitution itself. Today, courtesy after 1978, state of Karnataka, Rajasthan, although Bommai has taken the leap forward. And thereafter, even in Article 311C, the President's decision-making process in respect of armed forces can also be subject to scrutiny. So what are those matters that are open to scrutiny are all on the basis of fundamental rights and certain scheme of the Constitution which will advance the fair movement of the Constitution towards a higher social order. That's how one can look at it. But that would again not mean that by process of interpretation or a meaning given to words in the Constitution, one can enhance the quality of the working of the Constitution, raise it to higher levels of working. That is done. But to come back if the original provision of a Constitution has certain issues, then will it not be a matter for a parliamentary debate? Will not be a matter for a broader social democratic debate as to whether this provision should remain as it is? So that line of distinction, I think, is very important. So that's why I would like to answer both these questions a little later. Now, I was reading a book on administrative law in US. A very interesting observation. And I've tried to read it and then go further with my silence of the Constitution.
Yes.
This is how the author puts it. I've tried to kind of paraphrase it. The subtle problems of modern policy making are more akin to automobile design. I'll take a printout and give it out. The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. It's not that. No, I'm not reading. I'm just reading it from my hand. I'll just give it to you. I'll just hand it over.
What is the nature of what is the book?
It's a administrative law by Christopher Redley. I'll hand it over.
Administrative law by, what is the name of the author? Just give us the name of the author, that's all. By Christopher
Edley.
Edley.
I thought I was paraphrasing from that particular page.
Definitely. Yeah.
The subtle problems of modern policy making are more akin to automobile design or composition of a symphony. The artistry is in the complete vision and in the integration of subsidiary skills. No natural law assures us that a collection of skilled musicians will produce beautiful music. And no natural law of management assures us that a collection of experts will produce worthy administration. That's where all these problems arise. The whole is neither more nor less than the sum of the parts. But why I wanted to read it out is that we are looking at the design of the Constitution in certain parts where we think, is there something originally lacking in the vision, or it was not the original lack of the vision, but a later point of time in the understanding of the importance of the latent designs in the vision, and therefore there is something which is deficient in the understanding and the working of the Constitution. So if you're looking at the later part, deficiencies and in the understanding and the working of the Constitution, and therefore there is something which is wanting. That's why we all entered in the question of a vacuum, gap, and things like that. Probably I would like to pose an Ajay question. Apropos what this Bose had told me. We will take your lordships from Vineet Narayan onwards. And these are all areas where we are concerned with either the realization of fundamental rights have some issue, or there's some disability imposed, or the infringement is indirect. So on and so forth. One can probably multiply how, in the context of realization of fundamental rights, there is an issue. And that the court, therefore, is anxiety and concern to ensure, as a sentinel and the quivi, that fundamental rights shall anyway, in any manner whatsoever, impediment shall be, obstacle shall be removed and shall be facilitated, realization made possible. It's in those areas where, not that the court would imagine a vacuum, but there is an actual concrete situation when the court comprehends and says, yes, let me look at it and how do we handle the situation. Therefore, there's always a gap between in law and life. Holmes' famous statement is logic, experience, but Chief Justice Israel Barak and said, no, it is both. It's both logic and experience. I think that's correct. So that's why you're talking about the experience and also the logic behind it. But having said that, let me just take a quickly and then go back to mine. This book was written in the context of the unwritten Constitution of England. There are a lot of constitutional conventions which occupied parliamentary debates and how courts would look at you also come to page 10 of this. There is just the second paragraph. Abeyances should not be thought of. Page 10. Abeyances should not be thought of as empty constitutional gaps to be filled in through the normal course of legal interpretation and political development. Neither should they be seen as constitutional deals by which particular issues are attended through through a conscious form of mutual accommodation between contending parties, nor as conventions demarcating expected behavior through informal but generally obligatory agreements. On the contrary, abeyance should be seen as akin to barely sensed disjunction lodged so deeply within Constitution that far from being susceptible to orderly compromise, they can only be assimilated by an intuitive social acquiescence in the incompleteness of a constitution, by a common reluctance to press the logic of arguments and political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. 3 or 4 thoughts which are suggested here. The last part of it is that by a common reluctance to press the logic of argument on political authority to conclusive position, and by an instinctive inhibition to objecting to what is persistently omitted from the constitutional agenda. That's why we go back to the original constitution and we look at it as something which is taken, which is given. So it's one thing to say what the constitution says, and it's a different thing to say what the constitution means. And what the constitution means will often happen when the court is called upon to engage on, most importantly, on the rights of people. While it's certainly an important value in itself that an independent election authority is a fulcrum for free and fair elections, citizens' participation in a free and fair election, the enabling element, etc., all that is well taken. I don't think we need to have any debate on that at all. But in what context the court will be called upon to say, what is that you have failed to perceive? That's the only question that being presented. I have a 2-part note which I have prepared. I think it's been handed over to your lordships. I have been very ably assisted by Mr. Balbir Singh. We had a lot of useful insights. We had good discussions. I'm sure he will continue to assist your lordship in the best of his capacity. Before I read this note, and it's important that I try to come back on the instances of appointment, the durations, etc. I'll try to come back on that. Preferably if I get some factual data, I'll try to come back on that. I think it will be very useful for the court and may I just read a few parts of this part 1 of the submission. Paragraph Roman 2 at page 2. The concerns raised by the petitioners were debated in the Constituent Assembly, which finally approved 324 as it stands today. In the Constituent Assembly debates, Dr. B.R. Ambedkar submitted with regard to the appointment of Chief Election Commissioner and Election Commission. There are 2 alternatives before the drafting committee. You have a permanent body with 4 or 5 election commissioners that will be making the commission a permanent body, who would continue in office throughout without any break, or to confer powers on the president to appoint ad hoc body when the election will be annual. Or the 2 proposals consider, the drafting committee steered a middle course to have permanently in office and after chief election commissioner, leaving the conditions with the tenure and further appointments of any other election commissioner the will of the president. On the tenure of the election commissioners being made fixed and secure, Article 2, Section 2 of the US Constitution is considered, whereby certain appointments that specified therein cannot be made by the president without concurrence from the Senate. Dr. Ambedkar submitted the American practice a very dilatory process are likely to create administrative difficulties. Then, therefore, that's an important pointer to be kept in mind. If the other examples already before the Constituent Assembly, and those examples did not persuade the constitution makers to adopt them, either in the unmodified or any modified form, then probably the court will say that what way to the Constituent Assembly will have a certain amount of consideration and deference. It's one thing to say when you're debating in the parliament that what are the schemes would better serve the current needs of a society. And those parliamentary debates may travel or cover a wide range of concerns, issues, and data, whatever different political parties may come to fore in the parliamentary debates. So when therefore the Constitution as it originally enacted says, I take this course, at a very extreme point of view, I'm not, may not be seen as saying that there are certain insurmountable obstruction to the court navigating or steering constitutional surveys. I'm not saying that at all. But the extreme point of view, if the court were to say, we have some disagreements today on what the original Constituent Assembly thought about. And the disagreement may come in only in the context of experience. Experience saying that the independence of an electoral body has been mortgaged, either in the appointment process or in the removal process or in terms of conditions of service. See, if that experience is not very clearly delineated, I understand these instances may throw some light on that experience. I'm not shying away from that. But they must be so appealing enough and so disturbing the conscience of the nation and more particularly the court that this experience tells us that probably we need to have a relook, a second look as they call it. But what will the court then do? So will the court say, we have on deliberations in the course of engagement with counsel and parties, assistance of parties, etc., we think that this would be a more suitable course of action. That can be a problematic issue at some point of time. Why I want to say that, I'll come to it a little later. Because we are not now talking about a standalone provision in the Constitution, a standalone isolated instance where the court may take a view, and maybe it's the most appropriate view to be taken. And therefore, it doesn't become a precedent issue at a later point of time. But when the court may proceed to issues on a certain constitutional deliberative basis, say that this is what the government should do or the parliament may do. So I look at the various provisions of the Constitution where the Constitution has provided for an obligation or a duty or the parliamentary intervention at some point of time without indicating at when they will do it. So I have a large number of several instances in the Constitution where parliamentary intervention is proposed and suggested. So this may not become an isolated one-off instance, and therefore what the court may do, whatever little or minimal or whatever the court may do, may have some implications on the other aspects of Constitution where the parliamentary intervention is found desirable. I'm only looking at it from that point of view. I'm not even saying because of that you will not do that, but that will be kept in mind by the court. That will be a very important question that the court will keep in mind.
Yeah. Yeah.
The provision of the Constitution will take only to speak at least. Stick to the court. Part 2 of the note.
Yeah.
The part 2 of the note dealing with the concept of vacuum.
Part 2 of the note.
And there is an annexure A to that note.
Interfere.
Yeah. Yeah, we got it.
So I try to enumerate those other provisions of the Constitution where parliamentary intervention is looked at. Of course, the context may differ. There is some could be variations in the need, but just I've enumerated them. For instance, we have Article 10. Every person who is or deemed to be a citizen of India and any of the foregoing provisions of the part shall, subject to the provisions of any laws made Parliament, continue to be such citizen. Okay, there are many provisions where Parliament has enacted laws. So those are laws I'll try to point out where the need, the necessity, the urgency, which are probably built into the provisions themselves, is perceived by Parliament, and Parliament is proceeded to enact legislations. So therefore, it all depends on one, the context where parliamentary intervention is envisioned, and the need or the necessity is also felt by the Parliament. Parliament is enacted thereafter. So citizenship is a very important aspect of the Constitution. It must require parliamentary attention. Now, the Secretariat of Parliament, 98(2). Parliament may by law regulate the recruitment and conditions of service of persons appointed in Secretary of the Office of the Parliament. Until provisions made Parliament in a clause, so the President may, after consultation with so-and-so, make rules regulating the recruitment conditions of service to the Secretary of Staff, the House of the People, etc. Therefore, there are rules which have been made under 98(3). We skip then Article 137.
You are not for a moment suggesting to us that members of the Secretary to the Parliament are to be compared with Chief Election Committee.
No, I'm not saying. I'm not saying. No, certainly. I'm not suggesting.
I mean,
I'm only looking at. No, please don't mistake. Certainly. I'm not doing that at all. I'm certainly not. I'm only trying to enumerate those provisions where
We follow.
Parliament law.
It's very useful because
That's all.
we get it sort of one.
Then again, 137. Subject to the provisions of the law made by Parliament or any rules made in the Article 145. The Supreme Court shall have the power to review any judgment.
Just one.
I'm sorry, not just both of course.
Yes.
What I will do along with this, I'll give an additional note where Parliament either made rules or provisions or law. So that will supplement. That's right. So we don't have any parliamentary law as far as the 137 part is concerned. That's been entirely regulated by rules made under 145. But the Constitution equates parliamentary law to a rules made under 145 or rules made under 145. They are more or less placed in the same footing. Subject to the provisions of any law made by Parliament or any rules made in Article 145. So therefore, if the rule in 145, unless the Parliament thought that there is something more to be done by the Parliament, Parliament would have enacted. If they are sufficient enough to deal with the matter, and therefore, having regard to the high position the Chief Justice occupies in the consultative process, the Supreme Court employs welfare case thereafter. Then 142. Clause 2, subject to the provisions of any law made in this behalf by the Parliament, Supreme Court shall so and so all and every power to make any order for the purpose of securing the attendance, etc. There is no law as such on this subject. Again, Article 145. Subject to the provisions of any law made by Parliament, Supreme Court may from time to time, the approval of the President make rules. So by and large, only rules made by Supreme Court under 145, there is no law made by the Parliament. Then again, 146, we have clause 2. Subject to the provisions of any law made by Parliament, the conditions of service so shall be prescribed by Chief Justice under rules. Again, the same position, there is no law except the question of pay, condition, service of Supreme Court employees came before this court on comparison with condition service of High Court employees. And that's how the Supreme Court employee judgment came. Then 148, the salary and other conditions service of the Controller and Auditor General shall be such as we determine by Parliament by law, shall be as specified in the second schedule. Again, subject to the provisions of the Constitution and the law made by Parliament, conditions of service, etc., shall be such as to be prescribed the rules made by the President after consultation with the Controller and Auditor General. We have rules. I may then come to Article 243K. Subject to the provisions of any law made by the legislature of a state, the conditions of service and tenure of so and so shall be such as the governor made by rule determined. Therefore, the rules made by the governor in these regards. In Article 300, Government of India may sue or be sued by the name of the union and government of the state, etc., subject to any provision be made by Act of Parliament or the legislature of a state enacted by virtue of the powers conferred of the Constitution. Sue or sued in relation to respective affairs in like cases of the Dominion of India and the corresponding province, the corresponding Indian state, etc. And is often cited for the purpose of vicarious liability of the state and constitutional torts and so on and so forth. Then we have all these provisions, Article 338, National Commission for Scheduled Castes, and 338A, National Commission for Scheduled Tribes and Backward Classes. They're all constitutional provisions, and every one of them, each and every one of this provision talked about subject to provisions of law made by Parliament. And there are parliamentary legislations regarding their terms of appointment and who shall be appointed. Therefore, there are instances in Parliament to enact it. I'll give those instances. Again, in Article 367, we have, for the purpose of interpretation, the Parliament can always say who is a foreign state. Then turning over to the next page, for instance, in Article 21A, these are constitutional provisions which contemplate formation of law by Parliament, each one of them. So Article 11 talks about regulating citizenship by law, there is a law. Then Article 21A, right to education, there is a law. Then Article 22, Parliament may law prescribe circumstances with so and so private detention. There are legislations on private detention. Then 32, so of course, if Parliament has not so far done that, it's good that they have not done that. Then 33, you can skip that. Then Article 35, notwithstanding anything in this Constitution, Parliament shall have and the legislature of a state shall not have power to make laws with respect to matters which under clause of Article 16, clause of Article 32, so and so, we provide for law made by Parliament and for prescribing punishment, etc. There is no state law, of course, that's forbidden. In Article 59, conditions of President's office. So the second schedule continues to operate. Then Article 70, Parliament makes such provision as it thinks it for the discharge of the functions of the President, any contingency not provided in the chapter. There are some rules issued under Article 70, and 1969, there is a very skeletal law. Then in respect of these 71, Article 71, election of Vice President, there are legislations. 75, regarding ministers, the legislations and composition of council, all these where legislations have occurred. Again, for that matter, kindly turn to Article 102. It talks about disqualifications for membership. So we have provisions under the Representation of People Act providing for disqualification. There is a disqualification legislation 1959. Thereafter, a lot of amendments. And therefore, law has intervened, Parliament has intervened because they're very important, the life of democracy. You don't provide disqualification, criminalization of politics, all that. We have the intervention by this court in Association of Democratic Reforms, the right to know, being read into Article 19(1)(a). So Parliament has come. Then Article 105. In other respects, the powers and privileges and immunities of each house, Article 105, Clause 3. Of each house of Parliament and the members and committees of each house shall be such as in time be defined by Parliament by law, and so defined shall be those that are the House and members and committee immediately before the coming into force of Section 15 of the Constitution Zones Act 1978. Your Lordships know that so far there is no law relating to immunities and privileges. We have debated it from 1965 onwards, the Keshav Singh. So there's no law. Very important that freedom of speech within Parliament, outside, whether there is a complete immunity, so on and so forth, a matter of great importance. Then Article 119, regulation by law of procedure in Parliament in relation to financial business. Article 120, language abuse in Parliament. Why I may skip some of this provision. And you come to a provision like Article 239 AA. So this is a field which is now occupied by law. And so the reason is that territorial distinctions, state reorganizations, etc., are again matters of great importance for the federal structure of the country. And Article 267 relating to contingency fund, or just ahead of it, Article 262, interstate rivers or river valleys. We have a law relating to that, 1967. So it's an important, again, a federal issue and sharing of waters. And despite the Interstate River Water Disputes Act, we still have interstate river issues and commissions after commissions. And so these are examples where, having regard to a wide range of constitutional considerations and importance, Parliament has enacted and intervened. And some of those provisions may have some bearing on giving effect to the directive principles of state policy and so on and so forth. Let me take your Lordship through my part 2 of the note and then try to find out which is the best possible way of understanding these very important issues. And may I read it?
Yeah.
When an instrument of law is unable to serve its intended purpose, either on account of defects in its operation, enforcement, or implementation, or due to its purpose not being realized, it may be said there is a vacuum in the law. In the event that such a vacuum exists, and this Honorable Court, when engaged in dealing with specific instances of this issue, also finds that the intended purpose of the law is not being realized, it may, in furtherance, or the principle of enabling the realization of such purpose, embark upon the exercise of engrafting principles which may advance the same. This is different from the instances where no operational or functional deficiencies are demonstrated, but aspirational statements or an idealized situation which will meet that aspiration is set forth before this Honorable Court. The later categories of instances are ones that will preeminently call for political and parliamentary debate, whose outcome will be the creation of substantive legal norms or changes in the existing legal norms. This second category will not be a case of a vacuum to be filled. Interpretation of constitutional provisions towards effectuating enjoyment of fundamental rights is different from changing the text of the constitutional provision itself. In other words, such interpretative exercise will not and cannot enter into the domain of making substantive normative provisions in the Constitution. In this vein, it ought to be noted that the directives issued in Vineet Narayan were nothing beyond judicial approval of the recommendation made by the Independent Review Committee. These recommendations came to be approved of the Honorable Court as worthy of acceptance towards effective functioning of the concerned investigation agencies. The use of the word vacuum in paragraph number 14 of the judgment must be therefore seen with reference to proposition number 1 above. Similarly, Vishaka was an instance of a complete absence of a relevant legal protective framework towards safeguarding the concerns of women at workplaces. The issues relating to protection of women at workplaces, having been addressed in international legal instruments, this Honorable Court has persuaded to treat such legal instrument as a guiding and relevant factor for enacting domestic legal framework. The question in that case did not involve altering any existing constitutional or legal principles occupying the field. A comparison with Article 105 relating to the powers, privileges, and immunities of each of the Parliament may also be illustrative in this regard. Privileges and immunities have arisen regarding the power having been conferred on the Parliament and not having been exercised so far. This Honorable Court in Rajaram Pal so and so observed under. Similarly, if Article 1053 provides for the power for expulsion, though not so expressly mentioned, it cannot be said that a specific law in public interest is required. Simply because Parliament is given the power to make a law on the subject, there is no reason to say that a law has to be mandatorily passed, and the Constitution itself provided all the power to the House of Commons until such law is made. Thus, it is seen that even in the matter of such importance and relevance to both freedom of speech and also the powers, privileges, and immunities, the Honorable Court has not considered a non-enactment of a law by Parliament as a vacuum or a gap to be remedied by a writ of mandamus. Similarly, in several other provisions of the Constitution, the Parliament has been conferred the power to make laws.
This is very important what you have.
Yes.
This is the thing which is very important. You read on, yes.
Yes. However, the context, relevance, and the demand, etc., under those provisions vary greatly, and there can be no general proposition that in all such circumstances, the lack of an enactment by Parliament will be understood as a vacuum or a gap. That's a very important submission. I thought your Lordship will consider.
Very fair on your part.
What is being canvassed is, we say because there is an aspirational provision or an ideal situation to be attained, may be good enough. Therefore, imagine there is a vacuum because this is not there in position. Imagine a vacuum and then try to fill that vacuum. So that's why I thought it's important to look at the other scheme of the Constitution where you can't say simply there is a lack or a vacuum or a gap merely because Parliament has not enacted. So the wide range of considerations, policy, etc., will enter into the domain of decision-making process. While I say that great amount of responsibility, I don't want to be taken to mean that merely because it is so in other parts of the Constitution, certain very important schema of the Constitution will require special attention. And I say, no, you must close your eyes to that. But the reason is that you'll probably be very slow and find out whether, how do we really enter into the debate is the first question to be seen. So after the court enters into a debate and finds there's a room for a debate, then what the court will do, can do, or may do will be a second part of it. But the two are integrally connected. The petitioners herein place reliance on the 255th Law Commission report, dated 12/3/2015, the Dinesh Goswami report 1990, the report of the National Commission to review the working of the Constitution, and the report of the Administrative Reforms Commission, January 2007. These reports are essentially based on comparison with schemes relating to election bodies in different countries. The recommendations contained in the reports are not premised on any concrete set of facts, throwing doubt or concern as regards the working of Article 324(2). At best, these reports can be said to be aspirational and not critical of the current system obtaining under Article 324(2). Respectfully submitted, there are important conceptual differences between functional and operational vacuums in a statute, which may require remedial measures and intervention, and an aspirational ideal situation. Even in the case of functional or operational vacuums, well, the court will not always proceed to issue binding directions for enactment of a law or a rule or a scheme. It will be all the more so in the case of mere aspirational provisions. Article 324(2) does not contemplate that a law will have to be necessarily made to replace the system of appointment prevailing thereunder. The addition or insertion of a collegium structure in Article 324(2) will be a constitutional amendment. It will have to be in substitution of Article 74 of the Constitution, which provides that the President shall act under the aid and advice of the Council of Ministers. Such constitutional amendments, which are to be deliberated through parliamentary debate and intervention, cannot be subject for issuance of a writ of mandamus. The range of instances in respect to the Honorable Court has exercised the enforcement authority for fundamental rights under Article 32 are clearly distinguishable. Besides the fact that those cases are matters involving direct infringement of fundamental rights by reason of functional or operational deficiencies or gaps in the relevant law, or being cases wherein the enjoyment of fundamental right is not facilitated or enabled due to lack of a requisite legal instrument. In all other circumstances, this Honorable Court has declined to invoke the power of authority of mandamus. The Honorable Court has also declined either to issue a writ of mandamus or to command the enactment of a law where the statutory or constitutional provision in questions are of an enabling character. The University of Kerala, so and so, this a division in the Honorable Court framed the following questions for being referred to a larger bench. Whether the court by an interim order dated so and so can validly direct implementation of the Lingdo Committee report. Whether the order dated so and so really amounts to judicial legislation. Whether in our constitution the judiciary can legislate, and if so, what is the permissible limits of judicial legislation? Will judicial legislation not violate the principle of separation of powers broadly enshrined by the constitution? Judiciary can legislate in the opinion there is a pressing social problem of public interest, or it can only make a recommendation to the legislature or authority concerned in connection. The Article 19 once here, fundamental rights are being violated when restrictions are being placed on the implementation of the Lingdo Committee report with an authority of law. And what is the scope of Articles 141 and 102 of the Constitution? Do they permit the judiciary to legislate and perform the functions of the executive wing of the state? On a reference of being, such a reference being made, a bench of 3 honorable judges, while not entering into the question frame, observed as under. Submitted behalf of the party that acting on the recommendation so and so. Elections of students in are being held in their action according to their way. When the instant matter is called for hearing today, it was submitted behalf of the parties. Elections are presently being held in terms of so and so, etc. No issues, live issues survives the scrutiny of the court. In the view of the matter, we feel expedient to leave the issue at that for the present to be examined in future in an appropriate case if the occasion so arises. I just want to flag it so that that's right. In the instances that the Constitution prescribes the Parliament has the power to make a law, it can be for a variety of needs and circumstances. Therefore, merely because a parliamentary intervention is suggested in a provision does not mean that the court will interpret silence thereunder to mean that an explanation is owed to the court as to why a law has not been enacted. For the aforesaid reasons, and keeping in mind the separation of powers principle, the Honorable Court will please decline to entertain the above petition. Please come back to paragraph 10, again on the 4 reports.
Yeah.
At least I was part of these two reports, one the 255th Law Commission report and the report the National Commission to working with the Constitution. I was involved in it, and therefore I speak with some personal knowledge. What were the perseverance which went into the making of the report? And certainly the reports were made with high purpose of ensuring that the values of the Constitution shall be advanced. But I have one problem. Because today, unlike UK, the Law Commission's reports, I have a small survey of how many reports have become, translated into law. Roughly 50% of the reports have become translated into law. So 225, 100 reports, the rest 124, 25 have become law. The percentage of acceptance of reports in various Commonwealth countries ranges somewhere between 40 to 50%. So it seems to the position almost in all the Commonwealth countries. In Australia, again, the problem was different because issues like abortion, pregnancy, and certain other racial issues, that native tribes issues. So again, there has been a heated debate as to how do you accept certain reports, except through a parliamentary debate. So there is a convention now in UK. There's a protocol. Under this protocol, a Law Commission report of the United Kingdom is placed before the Parliament, and the Parliament then looks into it, and an action taken report is called for on the basis of that, then the government tries to proceed thereafter. We don't have that kind of a mechanism. Therefore, in the absence of a connect between the Parliament and the Law Commission reports, so if the court were to say, we find wisdom in the Law Commission reports, and therefore they should be considered for acceptance, that may invite a certain constraint on the government, and which Law Commission report should I accept for consideration. Therefore, there can be a possibility. The court says in this, yes, consider that. So that can again become a matter for repeated judicial intervention, that every Law Commission report will have to become a part of the law. Therefore, that important area where social, political, and other considerations which may enter into executive decision making, parliamentary intervention, parliamentary application, all that perhaps should be left as flexible as possible.
Attorney
Your
General,
Lordship.
if I may just,
And
you referred to various provisions of the Constitution.
Your Lordship, please.
Where, as enacted by the Parliament,
Your Lordship.
that expression finds space. And you have also brought in the context of what you are now submitting about the Law Commission reports and the Goswami Commission reports, that functional and operational vacuum, these are the words that you have used.
Your Lordship.
Now, if you revert back to Article 324,
And then
324.
324.
Now, here, what is the Election Commission expected to do? Superintendence, direction, control, preparation of electoral rolls, conduct of all elections, parliament, legislature, everything. So these are the various functions which are noted in sub-article 1. Now, Election Commission shall consist of these people. That is the other thing. Now, if that would have been the intention, was there any need subject to the provisions of any law made on that behalf by the Parliament? If that was not there, you would know that these are the functions to be done by the Election Commission. So somebody may be an outstanding cricketer. Your AG has been a cricketer of some repute. Somebody may be a great artist or a theatre person, but he may not be suitable for becoming an election.
Right.
So therefore, perhaps the constitution makers intended that in place, which will give an indication